Wait, did I see a plus sign by Edward Lewis?
Yes.
Bring him out for me, please.
Mm-hmm.
This is case number 224571601. The People versus Edward Lewis. Defendant is charged with weapons, I don't know what, and guns, reckless use. Today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people, and count one, Your Honor, is weapons, firearms, damage over $50.
Okay.
For the record, Your Honor, Janice Stevenson appearing on behalf of Mr. Lewis Edwards. Mr. Edwards, sir, please unmute and say your full name.
Lewis Aaron Edwards.
Today is the date set for pretrial conference. How are we proceeding?
Thank you, Your Honor. Mr. Edwards will continue his plea of not guilty. We would ask that this matter be set for final pretrial conference. We would request discovery.
The court continues a not guilty plea on behalf of Mr. Edwards and set the matter for a final pretrial conference. May 1st, 2024. Discovery should be submitted by April 2nd, I believe. No, April 1st. Bond will continue. Anything further?
Your Honor, it looks like the people sent discovery over on November 29th of 2023
Why would you have done that?
because there was an arraignment on the bench warrant on November 29th of 2023. And there's a pretrial set for today.
When I'm not here, I want y'all to please still set the things at the time that I normally set the thing. So if there's an arraignment on the bench warrant, he should have been at 8:25 or 8:29. Okay. So then the court will set up a final pretrial conference. For April the 1st. Well, wait a minute, February, no, let's go with, yeah, April 1st. At 9:00 a.m. Anything further?
No, thank you, Judge.
Okay, no, nothing further on behalf of Mr. Edwards. Thank you, Your Honor. And I
don't see anybody sitting on my front row. I don't see anybody sitting on the front row. Nobody. Ms. Stevenson, what are you saying?
I do acknowledge receipt of discovery, Your Honor. I see it in there now.
Okay, then we're all set, Mr. Edwards. Have a great day. Stay safe.
You too.
I'm ready on Leonard. This is case number 975882601. The People versus Lamont A. Leonard. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson on behalf of Mr. Lamont Leonard. Good morning, Mr. Leonard. Sir, please unmute and say your full name.
Hello, Lamont Emil Leonard.
Today is the date set for pretrial conference. How are we proceeding?
On behalf of Mr. Leonard, we would move for dismissal for the complainant's failure to appear.
Ms. Ritter.
Judge, it's the second scheduling of the pretrial conference, and this case is from 1997. The people tried to see if we could locate a complainant witness, which we could not. So at this time, Your Honor, the people will not be able to proceed.
All right, the court is going to grant defense counsel's motion. The people are unable to proceed. The complaining witness did not appear. Mr. Leonard, we will mail a copy of the order of dismissal for your record. Sir, have a great day and stay safe.
Thank you.
You're welcome.
Thank you, Your Honor.
Ms. Stevenson, are you ready on Barry or Lynise?
I'm ready on Barry. I'm not ready on Lynise.
Okay, can we bring Brittany Barry, please? I'm ready on Barry. This is case number 234567901. The People versus Brittany Michelle Barry. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Brittany Barry. Good morning, Ms. Barry. Ma'am, please say your full name.
Brittany Michelle Barry.
Today is the date set for pretrial conference. How are we proceeding?
On behalf of Ms. Barry, we would move for dismissal for the complainant's failure to appear.
Ms. Ritter.
Your Honor, I don't see the complainant witness, Mr. Matthew Calloway, in the waiting room. However, it's scheduled as a first-time pretrial conference. Respectfully asking the court to adjourn the pretrial conference and give the complainant witness one more opportunity to appear.
Today is the day set for pretrial conference. The court is going to deny defense counsel's motion for dismissal, grant the people's request for a one-time adjournment, giving them an opportunity to locate and notify the complaining witness of the obligation that they appear before the court. I'm going to set the matter for March the... Mr. Flanagan, how many do I have on March 4th, please?
$26.
And does that include 8:30 pretrials?
Yes, Your Honor.
We're just going to set the matter for March 4th at 8:36. The complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complainant could not appear or should not be required to appear. Bond will continue with no contact with the complaining witness. Anything further?
No, thank you, Your Honor.
Your Honor, I have a quick question. I believe the people indicated that they did not see Matthew Calloway present, and I just want to confirm the complaint shows the victim as Nicole Wright, that Mr. Calloway is the officer.
Ms. Ritter, who is the complaining witness?
It is Nicole Wright, Your Honor. My apologies.
Okay.
No
so
problem at all.
No contact with Nicole Wright. All right,
No.
Ms. Barry, we're all set then. Have a great day and stay safe.
Can Ms. Barry wait in the hallway for me, please, Ms. Barry, if that's okay?
Okay, go wait in the hallway for your lawyer. She's gonna come out and speak with you.
Thank you.
You're welcome. All right, I'm gonna go off screen anyway. Give me a five minutes and I'll be ready.
Thank you.
You're welcome. Ms. Ritter, you ready?
I'm ready, George.
All right, I'm ready on Breck. This is case number 234536601, the People versus Ian Hamilton Breck. Defendant is charged with operating while visibly impaired. Today is the date set for sentencing. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. May it please the court. My name is Matt Savage and I represent Mr. Breck. Ian, unmute yourself.
Mr. Savage, your P number, please.
51264.
Thank you. Mr. Breck, please state your name.
Ian Breck, Your Honor.
Today is the date set for sentencing. The court has had an opportunity to review the pre-sentence report. With respect to the report itself, are there any additions, deletions, or corrections on behalf of the people?
None on behalf of the people, Judge.
On behalf of the defense?
No, Your Honor.
With respect to sentencing, is there anything on behalf of the people?
Nothing on behalf of the people, Your Honor. Thank you.
On behalf of the defense?
Your Honor, Mr. Breck and I reviewed the recommendation by the probation department. We think it's fair. We're asking the court to adopt it.
Anything from your client? Would he like to make a statement on his own behalf?
Oh, go ahead, Ian.
I just want to apologize to the people in the community. I'm sorry, Your Honor. I see what I did was wrong.
All right, the court is ready to impose sentence. I will do so. In the following manner. Well, and let me just make an observation. So I did notice, well, according to the report, Mr. Breck, he wasn't charged. It appears to me that he wasn't charged originally with a second offense notice.
That is correct. It looks like the prior offense was outside of that 7-window conviction. That 7-year window conviction.
Okay.
Yes, I think it's way older than 7 years. I think it's a 2011
It is.
case.
But let me tell you what that says to me, though. That says to me that in 2011, whatever the probationary period and the jail time he served, it didn't take effect. It didn't take effect because I feel, and I don't know if they had him to view the consequences video. I don't know if they had him to participate or to view the victims impact panel, because I don't know that they do it in person anymore. I don't know what they had him do, but it seems to me like if a person was able to see those things and then still drink and drive again, are they really sorry? Do they really apologize? At what point did they realize that they were hurting the community? It seemed like if you have one, so if you have one, it seemed like during that one, you should realize the damage that you could do to destroy lives and kill people and maim people and injure people and hurt people. So when we come to the place that it's the second time, I don't know that I believe that the lesson was learned the first time. It clearly wasn't learned the first time. So nonetheless, there is a recommendation for a 15-month probationary period, and I am going to accept that recommendation for the 15-month probationary period. That places a final review date of April 1st, 2025. And then the court is going to set an interim review date, at which point Mr. Breck will not be eligible at that time for early discharge. But if he's on track, then we will set a date wherein he may be eligible for early discharge. So I'm going to set a review date for May the 2nd. Let me make sure. Yes, I'm going to set a review date for May 2nd at 10:00 a.m. The terms of your probation are as follows. You shall not violate any criminal law of any governmental unit. That means no new cases. You must report to probation on a monthly basis. You must notify probation immediately of any change of your address, phone number, or employment status. You must pay the following fines, costs, and fees. Mandatory cost of $210, a $500 fine, no restitution, supervision fees for the 15-month at a rate of $35 per month is $525. Of course, that is going to be prorated if he gets discharged early. And the court imposes a $100 pre-sentence investigation and substance abuse evaluation fee. Mr. Breck will submit to your analysis at least twice a month. If he tests at the 36th District Court, then he has to pay $10 drug testing fee to the 36th District Court. So I'm going to add $150. If they assign him to test outside of 36th District Court, the $150 will be removed and he will have to pay the agency directly, the agency where he tests. So the total fines, costs, and fees $1,485. Additionally, you shall not use or possess any illegal substances. You shall not use or possess any marijuana without a valid medical marijuana card. You shall not use or possess any opiates without a valid prescription and letter of explanation from the doctor. You shall not consume alcohol in any form. You shall not drive without a valid driver's license. You must attend and complete the alcohol safety education levels 1 and 2. You must submit to random urinalysis, as I indicated, twice a month. You shall attend the victim's impact panel, watch the consequences video. You shall I'm not going to order outpatient treatment at this time, but I'm going to indicate if any positive tests, then you must enroll in outpatient treatment. You must pay any outstanding tickets that you have with 36th District Court. According to the report, you have a $170 balance. I don't know what it's for, but you need to find out. If you have any outstanding warrants, which according to the report, you do not, but you must not have any outstanding warrants. We are going to mail a copy of this order to the Stratford Road address, and probation will contact you at the phone number ending in 8386. Anything further?
No, thank you, Your Honor.
Thank you.
All right, then, Mr. Breck, we're all set. Sir, have a great day. Stay safe. Council, have a great day. Stay safe.
You do as well. Bye, Ms. Ritter.
Ms. White, I'm ready. Well, I should have brought your client in earlier and made sure that he was connected. So your client is connecting. Okay. Meantime, I will bring in Ms. Jackson. Maybe you could call your client, Ms. White. I don't know. Oh, there they are. They're connected. All right, I'm ready on Wilson. This is case number 23579. 8601, the people of the state of Michigan. versus Jamar Arnell Wilson. The defendant is charged with 1 count of assault aggravated, and today is the date set for sentencing. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. Rita White on behalf of Mr. Jamar Wilson, P number P63046.
Good morning, Ms. White. Mr. Wilson, unmute and state your name. Mr. Wilson, unmute and state your name.
Can you hear me?
State your name.
Jamar Wilson. Good morning, Your Honor.
Good morning. Today is the date set for sentencing. The court has had an opportunity to review the pre-sentence report. With respect to the report itself, are there any additions, deletions, or corrections on behalf of the people?
Nothing on behalf of the people, Judge.
On behalf of the defense?
Nothing on behalf of defense. I did have a chance to go through the report with Mr. Wilson, and everything appears to be actually correct.
All right.
Actually correct.
Ms. Ritter, anything with respect to sentencing on behalf of the people?
So, Judge, with respect to sentencing, there was a plea agreement for a recommendation from the people for a term of probation, 24 weeks of anger management, restitution for any out-of-pocket expenses or medical expenses that the victim incurred, no contact with the complaining witness, Mr. Anthony Halliburton, and then consent to HIDA. I'm asking the court to adopt the recommendation from the people. The probationary term that was recommended by probation was 24 months. I would leave that in the court's discretion as to the term. But the 24 weeks of anger management, the people feel that it is appropriate and necessary in this matter, Your Honor. And the victim's statement on page 4 indicates that probation spoke with the complaining witness about restitution for any medical copays. They haven't received any paperwork. And I also spoke with the complaining witness on the day that Mr. Wilson took the plea. And I did indicate that he would need to send over any medical bills that reflects any copays that he paid. And I haven't received any. So right now the people are comfortable with the restitution being set at 0. Other than that, Judge, nothing further from the people.
Oh, you're on mute, Judge. You're on mute, Judge. I didn't hear.
Oh, there we go. Okay.
Sorry.
I just said anything on behalf of the defense.
Yes, Your Honor. We would leave the term of probation recommended in the discretion of the court. Mr. Wilson, actually prior to and during and now, has already been engaged in mental health treatment. When I actually spoke with him initially, he was actually inpatient in a mental health facility. So I would ask that the treatment he is receiving, that be just part and parcel incorporated into his program instead of adding additional treatment protocols, mental health wise, to him. Other than that, I would ask that you adopt the recommendation to include HIDA. And other than that, again, we would ask that we would leave the discretion of the term in the discretion of the court.
Would Mr. Wilson like to make a statement on his own behalf?
No, Your Honor.
All right. Court has had an opportunity to review the pre-sentence report. I'm not quite ready to impose sentence in that I have requested the mental health treatment court to log on to the Zoom. So I'm waiting on them to log on, because here's the thing. In reviewing the pre-sentence report, the court noted that Mr. Wilson, so in my opinion, at this particular time, I do not particularly see Mr. Wilson as a good candidate for probation. Mr. Wilson has a probation violation hearing scheduled on a 2022 conviction out of the 52nd District Court. Mr. Wilson also had he has pled guilty in 39th District Court previously on a probation violation, sentenced twice. He pled guilty to probation violation and was sentenced additional 3 months, additional 9 months. And then he also had 2 other probation violation in 52nd District Court in Troy, where his HIDA was revoked. So the people are saying they consent to HIDA, but he already previously got HIDA revoked. And so, but because I am keenly aware of individuals suffering from mental health issues, I try my best not to penalize, by jail individuals with mental health issues. I try my best. Sometimes it doesn't work, but I try my best. So what I would like to do, because I don't see him as a good candidate, I really, put forth a lot of effort in. Well, let me change my language. I used to put forth a lot of effort in trying to, get people to stay on the straight and narrow, change, do whatever. And of course, that is met with mixed reviews, which I don't care about the reviews in terms of, people agreeing or disagreeing with my method of trying to get people to change. But when I see that on at least 4 or 5 other occasions, other people have failed at what I'm trying to do, and that's not to say that I don't fashion myself to be able to do it. I do think in these types of situations that Judge Holmes and her team may be better equipped to handle it than me. I'm very happy that he was in some what sounds like intensive mental health treatment, and it's been my experience that. So, for example, I think you said that he is continuing in mental health treatment. It's been my experience that Judge Holmes they'll work with his present mental health treatment provider. So it's not been my experience that they make a person change from their provider, because when you're dealing with treatment therapy, it's best to have someone like who's familiar with you, who you connect with, so if you connect with the person, we're not going to change it. So what I would like to do, I don't did they say, Mr. Flanagan, how long it would take for them to log in?
They said they had to run a lean in about 5 minutes or so.
I mean, they always tell me that they have to run the lean first, and what I don't know why they do that is because by now they know that I'm not going to send them somebody with. Okay, let them run the lean. They're gonna run the lean and make sure I'm not sending them somebody with something that they can't do. But nonetheless, if he's not accepted into mental health treatment court, then I'll do something else. So Ms. White, what I would like to give you the option of, I want to see, I don't know what else is on your agenda for this morning, but I did want mental health treatment court to get a chance to interview Mr. Wilson. So if you wanted me to have Mr. Flanagan call you when they're done, we could do that, or text you when they're done, and then you could come back, as opposed to just having you wait here, unless you wanted to go in with them. But they're just going to interview him, get some information, explain the program to him, and then let me know if he's eligible.
Yeah, you call or text me. He can
Okay.
call or text me, and I'll be
Okay. So
Zoom
Mr.
back
Wilson,
on.
this is what I want to do. I'm going to send you to a breakout room, and then when the specialty court coordinator comes in, the case manager, I'll send them in there with you, and then they'll interview you, and then you get to tell me what you think. You know, you could, if you want to talk to your lawyer first before then you could talk to your lawyer first, and then we'll see if I'm going to send you to mental health treatment court. But I just in advance want to applaud you for addressing some of those issues. I do applaud you for doing that. So accept to join the breakout room, Mr. Wilson, and then hopefully they'll be on in about 5 minutes, okay?
No good.
Okay.
Thank you.
All right, you're welcome, Ms. White. We'll reach out to you.
Okay, I'll be back.
Okay. Ms. Stevenson, I'm ready on, let's get the jail, and then let's get Ms. Hernandez out of here. So let's do the jail. I'll bring in Ms. Hernandez. And then, okay, so let's see. This is Jeffrey Williams, case number 22-4539401. The people of the state of Michigan versus Jeffrey Williams. Defendant is charged with 1 count of indecent exposure. Today is the date set for pretrial conference appearances, please.
For the record, Your Honor, Christina
Hold
Ritter.
on. What happened to the jail? How did they go back to breakout? Okay, let's bring the jail back out. Okay, there they go. Not sure why or how that happened. So let me just recall the case 22-4539401. People versus Jeffrey Williams. Defendant is charged with 1 count of indecent exposure. Today is the date set for pretrial conference. Ms. Ritter, your appearance.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson, on behalf of Mr. Jeffrey Williams. Mr. Williams, sir, when they unmute you, please say your full name.
Jeffrey David Williams.
Thank you, sir. Today is the date set for a pretrial conference. How are we proceeding?
So, Your Honor, I would move for dismissal today. I do have a note about that the court instructed the people to get some information about who the complaining witness is, whether or not that individual is a Wayne County Jail employee.
Ms. Ritter.
So, Judge, it looks like, according to the notes from Mr. Henderson, I don't see the information on whether the complaining witness is an employee of the Wayne County Jail.
You say you don't see the information. What do you mean? Okay, so I'm not sure what that means though, Ms. Ritter. So today is the date set for pretrial conference. It is the second scheduling of the pretrial conference. I think I remember, based on Ms. Stevenson's statement, that I did have a case where the incident occurred in the Wayne County Jail. And so therefore I said that if it was a Wayne County sheriff, well, of course, not the Wayne County sheriff, but if it was a deputy sheriff, that I wasn't going to require their appearance. But if it was, if it wasn't a sheriff, then the complainant would have to appear. So you're saying the people don't know if it was a deputy sheriff?
No, Your Honor, Mr. Henderson didn't involve any notes whether he inquired on if the complaining witness was a Wayne County sheriff.
Your Honor, according to the complaint lists the complainant as James Jones, and the investigator's report refers to that individual as an inmate. I would therefore move for dismissal for the complainant's failure to appear.
Today is the day set for pretrial conference. Well, before I do that, deputy, is there a deputy near Mr. Williams? I mean, that name is so common though. So I don't know how they gonna, why do the jail keep disappearing? What is the jail doing? Oh, there they go. Deputy, okay, Ms. Stevenson, does the investigator's report, other than listing the person as an inmate, does it list their inmate number?
Let's see. Yes, it does, Your Honor.
Okay, deputy. I don't know what they're doing. Good morning, Ms. Hernandez.
Good morning, Your Honor. How are you?
I'm well, thank you. We'll be ready on Lynise in one moment.
Perfect. I'm just out of the video because I cannot change it from here.
Yeah, I just enabled it.
Okay,
I had
perfect.
it.
No problem.
Mhm.
Okay.
Ooh.
I look better in that picture.
Me too, Miss Hernandez. Me too. Look, it's a young look. My picture is it's a younger version of me.
Yeah, mine too.
The jail cannot unmute. Why? Why can't the jail unmute? Okay, hold on. Well, I can't unmute you. You got to unmute yourself. You have to unmute yourself. I can't unmute you. Okay, is the jail unmuted now? I can't.
Yes, Your Honor, it is.
Oh, okay, there we go. So, deputy, is it possible for you to check? If I give you an inmate, is it possible for you to check to see if you all still have the custody of this inmate?
Yes, Your Honor.
Okay, Miss Stevenson, even though I know it's not, well, Miss Ritter, let me not let Miss Stevenson. Miss Ritter, do you have the investigation report?
I do, Judge.
Okay, so can you get the inmate number to give to the deputy?
Yes, Your Honor. I'm pulling it up right now, Judge. Judge, it looks like the copy that I have, the inmate number is redacted.
Well, how do Miss Stevenson have an unredacted inmate number?
Can I just get the last name and first name, please?
It's a very common name, deputy. That's why I was trying to do something different. But Miss Ritter, what's the name of your witness?
James Jones.
Exactly. A very common name. But see if you have any James Joneses in your custody.
Do we have a date of birth for Mr. James Jones?
Right, no. Miss Stevenson, can you give me the inmate number again?
Check his housing.
Let's see if
21
this, I want to know how Miss Stevenson has an unredacted copy, but what's the inmate number that you have, Miss Stevenson?
21-4545.
Your Honor, that person is not in our custody.
Okay, thank you. All right, so with respect to Mr. Williams, today is the day set for the pretrial conference. The complaining witness is not a deputy sheriff and in fact was a former inmate at the Wayne County Jail. Therefore, he is required to appear today. He has failed to appear. People have no explanation for the failure to be able to proceed. The court is going to grant defense counsel's motion. The matter is dismissed without prejudice. Mr. Williams, we're going to send over to the jail a copy of the dismissal for your records. Have a great day and stay safe. Oh, you're muted again, and I can't imagine what you need to say, but I'll send you to the breakout room and you can ask Miss Ritter. I mean, oh, no, sorry, Miss Ritter. She like, I'm not no defense attorney. You can ask Ms. Stevenson. I'll send the jail back to the breakout. Good morning, Mr. Page, who I didn't recognize in person when he came in to the courtroom.
Good morning.
All right,
How are you?
I'm wonderful, thank you. How are you?
I'm good.
Mr. Page, I'm going to send you to breakout room number 10.
Okay.
Ms. Stevenson, go ahead and see what your client wants and then come right back. Can I get Mr. Lynise to the podium, please? Ms. Stevenson, you went in there that quick?
I went to the wrong room.
Oh. Can you go back and see what you're going? Okay, can the
Okay.
person on the Moto G Power please unmute and state your name? Can the person on the Moto G Power please state your name?
Curtis Dyer.
Thank you. Mr. Dyer, please accept to join the breakout room and wait for the lawyer to come in to speak with you, sir.
Okay.
And the device identified as specialized care services, please unmute. And the device identified as specialized care services, please unmute. Can the device identified as specialized care services, please tell the court who is present?
Your Honor. Destiny Janzeski. Can you hear us now?
I can hear you. And please.
I'm trying to get the video going. I'm so sorry.
Okay. Shh. I didn't ask for the video. I asked you to tell your name.
Destiny Janzeski.
Thank you. Please accept to join the breakout room and the lawyers will come in to speak with you.
Thank you. Thank you, Your Honor.
You're welcome. Ms. Hernandez, you could turn on your video. I'm ready.
It says I cannot start video
right.
because the host has stopped it.
You're right. Okay, now you can.
You're in charge.
Now you can start the video.
Okay, hello.
Hello. All right, Ms. Hernandez, raise your right hand for me. Do you swear or affirm you will translate from English into Spanish anything I say, counsel says, or perhaps the clerk says, and from Spanish into English anything Mr. Lynise says, oh, and from English into Spanish anything Ms. Baker says, to the best of your ability?
I do, Your Honor.
Thank you. And I'm sorry, state your name for the record and your title, please.
My name is Emma Hernandez, Your Honor, as CAO Qualified Spanish Interpreter, number 15575.
Thank you. All right. This is case number 235846901, the People versus Bryant, Adali Lynise.
Este es el caso de el pueblo contra el señor número 2305846-901 contra el señor Bryant Adali Lynise.
The defendant is charged with 1 count of assault or assault and battery, and today is the date set for final pretrial conference.
El acusado ha sido acusado de un cargo de agresión o agresión con lesiones y hoy es el día agendado y la hora agendada para la consulta final previa al juicio.
Appearances, please.
Sus comparecencias, por favor.
For the record, Your Honor, Christina Ritter on behalf of the people.
Para que conste en el acta, señora Cristina Ritter, representando al pueblo.
I have the complainant witness present via Zoom this morning.
Y yo tengo aquí a la testigo acusadora aquí en la habitación conectada en el día de hoy.
Ms. Baker, unmute yourself and state your name for the record, please.
Señora Baker, por favor, abra su micrófono y ponga su nombre para que conste en el acta.
Olivia Baker.
Olivia Baker.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Mr. Brian Lynise. Mr. Lynise, sir, please say your full name.
Y para que conste en el acta, su señoría Janice Stevenson representando al señor Brian Lynise. Señor Brian Lynise, por favor, diga su nombre completo para que conste en el acta.
Brian Adalid Laínez Lanza.
Brian Adalid Laínez, your last name, please. Señor, su segundo apellido.
Lanza.
Lanza. Brian Adalid Laínez Lanza.
All right, today is the date set for pretrial conference. How are we proceeding?
Está bien, hoy es el día y la hora establecido para la consulta previa del juicio. Abogada, ¿cómo desea proseguir?
Your Honor, the people have tendered an offer to Mr. Lynise, which I would like the opportunity to discuss with him.
Su señoría, la fiscalía le ha extendido al señor Lynise una oferta, la cual me gustaría discutir con él.
Why can't we discuss it with him right now? You're in person and he's in person.
And
¿Por qué no le podemos hablar eso ahorita? Usted está en persona y él también está en persona.
And I would ask the court for the opportunity to do that, Your Honor, and that the complaining witness is present today.
Y yo le pido la oportunidad de hacer eso a la corte, ya que la testigo acusadora se encuentra presente en el día de hoy.
Oh, okay, well, Ms. Stevenson, why didn't we get him ready already? Okay, let's go ahead and get him ready.
Ok, yo pensé que eso ya estaba listo, pero bueno, siga adelante para estar listo con eso.
Your Honor, I do need the services of Madam Interpreter because this is a pretty complex situation.
Su señoría, yo necesito la asistencia de la señora intérprete porque es una situación bastante compleja.
All right, I'll send the interpreter to the breakout room.
Está bien, yo voy a mandar entonces al intérprete para la sala de consulta privada.
You and Mr. Lannis can join her after we do Miss Israel's sentencing.
Entonces podemos, tanto usted como el señor Lynise pueden unirse a esas mismas salas de consulta privada después que yo termino con la sentencia que tengo que dictaminar ahorita.
All right, Miss Hernandez, you can go to breakout room number 8.
Thank you.
You're welcome. Mr. Lannis, go in the hallway. Miss Baker, hold tight for a moment. I'm going to put you back in the waiting room. Mr. Flanagan, I don't know who you spoke with respect to Mr. Kinney, but maybe we can get an update. Maybe you could try to get an update. He didn't say which room he was in.
Judge Cobb.
Okay, maybe you could call Judge Cobb's courtroom and see what Mr. Kinney's ETA will be.
Okay.
Thank you. Mr. Edmondson, good morning. Please accept to join the breakout room and wait for the lawyers to come in to speak with you. All right, Miss Israel, can you sit back some from the, yes, that's better. Thank you. Okay, this is case number 19-450-3501. The people of the state of Michigan versus Denise Ginyard. Defendant is charged with 1 count of child abuse, 4th degree. And today is the date set for sentencing. And for the record, and according to the pre-sentence investigation, Ms. Ginyard has legally changed her name to Jediah Israel. And so for the record, I will be referring to Ms. Ginyard as Miss Israel. So when the case name is Ginyard, but her name has been legally changed. So if everyone can refer to her as Miss Israel, that's her now legal name. All right, appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Ms. Jediah Israel. Ms. Israel, ma'am, please unmute and say your full name.
Jediah Israel, formerly known as Denise Ginyard.
Thank you, ma'am. Today is the date set, and I said that first name so wrong. I didn't even look at it right. When Ms. Stevenson said it, I looked at it. I said, you sure did leave out that whole middle part. So forgive me. All right. Today is the day set for sentencing. I have had an opportunity to review the pre-sentence report. With respect to the report itself, are there any additions, deletions, or corrections on behalf of the people?
None on behalf of the people, Judge.
On behalf of the defense?
On behalf of Ms. Israel, Your Honor, we have had the opportunity to review the pre-sentence investigation report. I just want to double check one thing. Yeah, we have no additions, deletions, or corrections, Your Honor. Ms. Israel does stand ready for sentencing.
All right, and then with respect to sentencing, anything on behalf of the people?
Judge, with respect to sentencing, I would ask the court to adopt probation's recommendation for a 1-year term of probation. Instead of the anger management, though, Your Honor, the people would recommend parenting classes if that is appropriate in lieu of anger management. Other than that, Judge, there is nothing else from the people as far as sentencing.
All right, Ms. Stevenson.
On behalf of Ms. Israel, Your Honor, we would concur with the people's recommendation. This is a parenting situation, not a situation where Ms. Israel was lashing out at her then 4-year-old child of anything of that nature. We would further advise the court that there was a CPS case in this matter. Ms. Israel did fully comply with all the terms and conditions of that CPS case, and it has been closed. One of the conditions was that she complete parenting classes. That child, Your Honor, is now 9 years old, and although she does live in the same house with Ms. Israel, the child is actually in the care and custody of Ms. Israel's mother. So Ms. Israel's mother is the child's guardian, even though they do all live in the same household together. Ms. Israel was under the impression that once the CPS case was concluded, that the entire matter was taken care of. She didn't even know that a warrant was outstanding until, I don't know, maybe several years later, she went to apply for a CPL, and that's how she learned that the matter was outstanding. I have advised Ms. Israel that that there is still a possibility that the court would, despite the fact that she finished parenting classes, still order some parenting classes, so that the court does have a comprehensive view of the situation. Ms. Israel is pregnant right now. She's expecting a baby within probably about 2 weeks. She also has 3 other children that she has care and custody of that are living with her. So she actually right now lives with, well, when the baby gets there, that'll be 5 of her own children. So she understands the court may order some additional parenting classes. Ms. Israel is ready, willing, and able to come fully into compliance with whatever the court's order is. She has no criminal history whatsoever. So we are asking the court to follow the people's recommendation, including the delayed sentence, Your Honor.
Okay, and would Ms. Israel like to make a statement on her own behalf?
Ms. Israel, if you, there you go.
Oh, okay. I'm still learning. No, ma'am. I accept whatever I'm given.
Court, as indicated, had an opportunity to review the pre-sentence report. I'm ready to impose sentence and do so in the following manner. The court is going to impose or accept the recommendation for a 12-month probationary period, putting a final review date for January, strike that, January 31st, 2025. Ms. Israel has an opportunity for early discharge. After 6 months, the court sets a review date for July the 2nd, 2024 at 10 o'clock a.m. Imposing the following conditions: you shall not violate any criminal law of any governmental unit. You cannot leave the state of Michigan without consent of the court. You must make a truthful report to probation on a monthly basis. You must notify probation immediately of any change of your address, phone number, or employment status. You will pay the following fines, costs, and fees: $210 mandatory cost, a $50, strike that, $75 attorney's fee, a $300 fine, no restitution, $420 oversight fee at a rate of $35 per month, $50 pre-sentence investigation fee for a total of $1,055. You shall not use or possess any illegal substances. No marijuana without a valid medical marijuana card. No opiates without a valid prescription and letter of explanation from the doctor. You shall not drive without a valid driver's license. I'm not going to order random urinalysis, but I am going to indicate that I want at least one test at the discretion of probation. Court is going to impose the following additional conditions. I agree with Ms. Ritter. I'm not going to impose anger management. That's not an appropriate recommendation. I'm going to impose parenting classes instead. And no, I won't accept the prior parenting classes. I want some new parenting classes. So we are going to order parenting classes. And I'm going to say 12 weeks. Pay any outstanding tickets that you may have. According to the report, you don't have any. Oh, and then I don't think I said it, but I will accept also the recommendation for a delayed sentence. Depending on how she does. So I'm gonna do this. I'm gonna also indicate choices, but I'm gonna hold it in abeyance. If she does well with attending the parenting classes, and you know, she does well with the probation, if she gets discharged at the 6-month mark, I won't impose the choices program. We are going to mail a copy of the order to your Tracy Street address, and probation will contact you at the phone number ending in 9738. Good luck with your the birth of your new child that's coming. So of course, I'm not expecting much compliance in the first couple of months of her probation, but make sure you know that you have 12 weeks of anger management. So if you, I'm not anger management, I'm sorry, of the parenting classes. So, you know, as soon as you're able, you should start attending those classes, okay? So that you don't have to go beyond, you know, if possible, so that you don't have to go beyond the 6 months, okay?
Yes, ma'am. Is it a at-home parenting, like they come to the house and see the children, or is it at a facility?
I'm sure it's not at home.
Okay.
But it may, I don't know how they run the classes, but they may be, some of them still may be virtual. So you have to ask probation about that. I'm sure that they can accommodate in some way, especially since you're gonna be just, you know, having another baby. So they should be able to accommodate in some way. But you ask them about that, okay?
Yes, ma'am. Because when I did it, it was at home. The lady came out to the house every
Oh,
week.
really?
Yes, ma'am. In
Oh,
2019, when I first
that
did
was
it.
right before COVID.
Yeah, I think that's probably, it was 2018 going into 19 because
Right.
I had just had my soon to be 6-year-old at the time. So this is why I didn't know anything about this, as my lawyer stated, because I thought it was over. She told me it was over. She said the case was closed. So
Yeah, but she meant the CPS case was closed. She didn't know, and she couldn't tell you about the criminal case.
I didn't know it was a criminal case because I'd never been in trouble with the law. So I would have literally got it handled at the time of it being, because I didn't find out until I tried to get my CPL 2 years ago. So I do apologize because I'm unaware of this. I would have been got this handled because it kind of scared me, because I thought I was gonna go to jail and different things, because I'm like, I never done nothing and I didn't know.
Mm-hmm. Yeah, well, I mean, I understand the confusion. But I don't know if they're coming out to houses anymore. I don't think they're coming out to houses anymore, but you could talk to probation about it. And then if there's some type of issue, we can, Ms. Stevenson can try to address it with me before we get too close to the 6-month mark, okay?
Yes, ma'am.
All right. Then we're all set. Have a great day. Stay safe.
You too. Thank you.
You're welcome. Okay, Ms. Stevenson, go ahead and get Mr. Landis ready.
Yes, Your Honor.
Okay, Mr. Page, Mr. Wilson. Mr. Wilson, are you there? Mr. Page, he's eligible.
here.
Is he eligible?
Yes, ma'am. I spoke with him about the program. He is eligible and he is willing to work it as well.
Okay, Mr. Wilson, you didn't want to talk to your lawyer or anything first? We can. I mean, you understand the program?
I can't hear you fully right now. 1 second.
Okay. Mr. Flanagan,
All
go
right,
ahead. Hello. Can you hear me?
Yeah, I can hear you.
Okay. I was just asking you, did you want to talk to your lawyer first or anything? That's all.
I talked to my lawyer, but
Okay.
also I wanted to let you know as well, Judge. I do feel more comfortable with, as far as just going through with the HIDA. That's something that I just want to go through with as far as redemption wise, and I trust myself to complete that within your orders.
Okay. Well, hold on. So, Mr. Flanagan, let Miss White know that we're ready again.
Okay.
All right. So, Mr. Page, if I was to send Mr. Wilson to the specialty court, what date would I give him?
Can you give him February 9th, next Friday?
Okay, then Mr. Flanagan will let you know. Thank you, Mr. Page.
Okay, thank you so much.
All right, have a great
Bye-bye.
day.
You too. Bye-bye.
Uh-oh, did Mr. Wilson leave? Did he leave? He wasn't supposed to leave. Oh my goodness, he left. He might have misunderstood. What? Maybe his phone messed up. Okay. All right, well then I need to wait on the lawyers, so we're on a little break. Soon as I said that, then here come Miss Hall. Hold on, give me 1 second. I was gonna go fill up my coffee cup, Miss Hall. Give me 1 second.
Okay, so just so you know, Your Honor, I'll be standing in for Mr. Kenny on Williams.
Just so Mr. Kenny know, you can't do that while you serving with MFD.
Oh, okay. Well,
Yeah, tell Mr. Kenny you got to get somebody else other than MFD to serve. You can't handle other cases while you for MFD.
Okay, but she's not here, correct?
Yes, she is. She's sitting right there on the front row.
Oh, in the courtroom. Okay, all right. Thank you.
You're welcome.
Your Honor,
Yes.
that's Miss Horton.
Oh, okay. Well, but I thought y'all told me Miss Williams was here.
She is. That was the one that was out of dress code, Your Honor.
Okay, but she's here. But okay,
Yeah.
see here.
I was just like,
Oh, nobody told me about Miss Horton. That's who?
Gail Horton, under 825.
Okay.
Yes, it's in the chat.
Okay. Mr. Wilson, I'm going to send you back to the breakout room to speak with your lawyer. Whoops, and then I'll recall your case. Ms. White. Ms. White, are you there? Ms. White? Ms. White? Okay, well, I guess I'll wait. Are we ready to recall on Lynise, please?
I'm ready to recall Lynise, Your Honor, and I am going to have a request of the court.
All right, recalling case number 235846901, the people versus Bryant Lynise. Okay.
Yeah. Sorry about that, Your Honor. I'm here.
Okay, Ms. White. Your client wanted to speak to you. I'm going to send you to the breakout room with him. He already spoke with Mental Health Treatment Court.
Okay.
All right, with respect to Mr. Lynise, Ms. Stevenson.
Estamos llamando nuevamente para que conste en el acto el caso del señor Bryant Lynise, número 2305846901. ¿Está bien, señor Stevenson? ¿Qué desea hacer con su cliente?
Your Honor, I would request that this matter be briefly adjourned to a time convenient to the court and Madam Interpreter for Madam Interpreter to be in person so that we can.
Su señoría, yo voy a pedir por favor que este caso sea aplazado brevemente de manera que lo podamos manejar con la señora intérprete en persona.
Because what? It didn't work? You couldn't talk to him right there in your office?
¿Por qué? Porque usted no trabajó, usted no pudo trabajar con él aquí en su oficina.
No, Your Honor. It has been difficult in the past for me to be confident that Mr. Lynise is able to hear the interpreter and so that she can properly hear him and translate, Your Honor.
Su señoría, mi experiencia anterior ha sido, ha sido dificultoso que para yo estar segura que el señor Lynise entiende la intérprete, igualmente el intérprete del señor Lynise, cuando no ha sido en persona.
Ms. Baker, unmute yourself, please.
Señora Baker, por favor, abra su micrófono.
Ms. Baker, what day I believe I recall you coming previously, and so it appears that you want to participate.
Señora Baker, ¿cuándo usted ha venido antes y ha estado dispuesta a participar?
So what day is good for you? I'm going to grant the adjournment so that the interpreter can come in person. What day is good for you?
Yo voy a aceptar la solicitud de que la intérprete pueda venir en persona. ¿Qué día es mejor para usted?
Now, you don't have to come in person, Ms. Baker, but I'm just saying what day is good for you.
Ok, señora Baker, usted no tiene que venir en persona. Simplemente estoy preguntando qué día es conveniente para usted.
If you give me a date, I can check and see if it works.
Usted me da una fecha, yo puedo chequear y ver si funciona.
Ms. Hernandez, what date can you come down?
This week, I can only go in person in the morning on Friday. In the afternoon, I can do Monday, Tuesday, and Friday. And next week, the same. I'm full. I could do the 15 in the morning.
Let's go to next week. You said next week you could do in the afternoon on what day?
The 12th, Monday, the 13th.
No.
Tuesday.
The week next week, the 5th, the week of the 5th.
Okay. I can do, I'm sorry, the 5th, I can do in the afternoon about 1:30 and on, also on Tuesday, and also on Friday.
Can we do Miss Baker Monday or Tuesday of those 2 days, which is better for you to come in the afternoon? So you would log on at 1:30.
Okay, let me look at my calendar. Tuesday would work better because she said after 1:30 and I have classes until 1:20.
Okay, so let's do Tuesday, February 6th at 1:30.
Okay.
All right. And then, so for Ms. Hernandez, Ms. Stevenson, and Mr. Landis, those are in person. So let's put it at 1:32 on the docket. And then we should be in trial. So I should be in person as well.
Está bien, entonces vamos a tener la próxima fecha. Es conveniente para la señora Baker conectarse y para el señor Lynise, la señora Stevenson y la intérprete señora Hernández para estar en persona el día martes 6 de febrero a la 1:30 de la tarde. Martes 6 de febrero a la 1:30 de la tarde.
All right, anything further?
¿Alguna otra cosa?
That's in front of people, Judge. Thank you.
Nothing on
Nada por
behalf of
parte de la
Ms.
Fiscalía, su señoría, gracias.
Nothing on behalf of Mr. Lynise. We thank the court, we thank the people, we thank the complainant and Madam Interpreter.
Nada por parte de la Defensoría. Agradecemos a la Corte, a la Fiscalía, al señor acusado y a la señora intérprete.
All right, we're all set. Have a great day. Stay safe.
Entonces está bien, mande que tengan un buen día. Your Honor, I will wait for the request from Court Reporting Service as always, but I'll be there.
Okay, yes, we'll send it over.
Perfect. Thank you. Bye-bye. Nice to see you all.
All right.
Do you want me to tell him something to Mr. Lynise?
Miss Stevenson.
Muchas gracias, bendiga. Voy a estar aquí el martes.
No lo oigo.
Muchas gracias, Dios les bendiga. Voy a estar aquí el martes.
Okay, thank you very much. God bless you. I will be here on Tuesday.
All right. Thank you.
Okay, bye-bye.
Mr.
Bye-bye,
Wilson.
everybody.
Bye-bye. Thank you, Ms. Hernandez. Mr. Wilson, sit up for me.
Your Honor, if I may.
You may.
I just wanted to inform the court that Mr. Kinney is walking over from Frank Murphy now.
Thank you. Mr.
Yeah,
Wilson.
as far as my phone is on the charger right now because the only reason I got out of the last session was because my phone had died. It's on the charger right now. This is as suitable as I can get.
Okay. All right, Mr. Wilson. All right, we're back on the record with case number 235798601, the People versus Jamar Arnell Wilson. Okay, so Ms. White, I had an opportunity to have Mr. Wilson speak with the case manager from the specialty court, and he is eligible for specialty court. And if I sent him there, he would have a court date of February the 9th to see Judge Holmes. You've had an opportunity to speak with your client with respect to that. How do you wish to proceed?
Yes, I have spoken to Mr. Wilson, and he did again speak with the department that handles the mental health court. He would like to participate.
All right, and of course he had said something to me about HIDA before you came in, so I wanted to assure him that he is going to get HIDA. So even going to the specialty court, he's going to get HIDA. We're going to go ahead and suppress the case now. Let Judge Holmes know that it is suppressed, and then he'll still get HIDA at the conclusion of if he completes the program, or it'll be still dismissed completely. So I think it's a great idea, Mr. Wilson. I am a strong proponent of mental health treatment, and so I'm looking forward to you gaining everything that you need from that program. So we're going to go ahead and there was a recommendation for 24 months, probationary period, but the specialty court program only requires 14 months. And so even though there was a recommendation for 24-month probation, I'm only going to sentence him at this time to 14 months. Because once he completes the specialty court program, there's no need to continue, just on probation. That program is more intensive than regular probation. And once he completes it, he'll be done. He doesn't have to stay on for 10 more months. So I'm going to set a final review date of April the 1st. Now, Judge Holmes may change that, but right now that's the review date, 14 months, and then I'm going to refer him, or I'm going to transfer him to Judge Holmes. His next court date is February 9th. I'm pretty sure that is in person, and he didn't tell me a time, but I think it might be 8:30 or 8:45. They are going to contact Mr. Wilson before that date. That's my experience, that they always do. And then Ms. White, I don't know if you were retained or appointed.
I was appointed.
Okay, so there are, I think, 2 or 3 lawyers that works with the defendants in the specialty court program. So they will take over the representation for Mr. Wilson. Okay?
Great.
Mr. Wilson, good luck to you. And I'm sure everything will work out great for you, okay?
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
You're welcome. Have a great day. Stay safe.
You
All
too.
right, no, you too.
All right. Okay, I'm ready on craft. And then I'm ready on, it looked like I saw Miss Stevenson talking to Miss Horton, so she may be ready on Horton, but I'm ready on craft. And then I don't see, oh, okay. Did y'all tell him his client isn't properly dressed for court? But this, okay.
Yes.
I'm gonna deal with that. It's looked like the first time appearance. Mr. Officer Crafts, make sure we have,
I gave her address.
okay, that's great. Okay.
Bring her in, Your Honor, with Mr. Kenny.
You can, you can. I need you all to back the camera up a little bit. I need Mr. Kraft to start his camera. Hey. Okay. Mr. Kraft isn't starting his camera, so I'm ready on Williams. I'm ready on Williams. And then if Mr. Kraft starts his camera, then I'll be ready on Kraft. But if not, I'm gonna move on to somebody else too, because Mr. Kraft then went on a break. This is Williams. Good morning, Mr. Kenny.
Good morning, Judge. I apologize.
Oh yeah, no problem. They told me you were in circuit court. I know how that can be. Sometimes. All right, this is case number 214422901. The People versus Sharika Lynn Williams. Defendant is charged with one count of assault or assault and battery. Today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Judge. Robert Kenny appeared on behalf of Ms. Williams. She stands to my left.
Your P number, counsel?
35842.
Thank you. And Ms. Williams, your name, please.
Sharika Lynn Williams.
Thank you, ma'am. Today is the date set for a pretrial conference. Mr. Kenny, how are you proceeding?
We would like a trial date, Judge.
Okay. Ms. Ritter, did the complainant appear?
So, Judge, I have notes that the court set this pretrial conference today at 8:25, and a complainant witness was required to appear. I don't see the complainant witness, Ms. Jaria Jordan, in the waiting room, and I don't have an explanation as to why the complainant witness is not present. At this time, Your Honor, the people will not be able to proceed to a trial based on the complainant witness's failure to appear.
Mr. Kenny?
Well, if you will entertain it, a motion to dismiss.
Why does Mr. Kraft have on a hat? Did he have on a hat when MFD talked to him? Why does Mr. Kraft have on a hat? Mr. Kenny, with respect to Mr. Kenny, today is the day set for the pretrial conference, or I'm sorry, with respect to Mr. Kenny's client, Ms. Williams. Today is the day set for pretrial conference. The complaining witness was required to appear. They failed to appear. People have no explanation for the failure, and they are unable to proceed. The court is going to grant defense counsel's motion. The matter is dismissed without prejudice. Mr. Kenny, since you are in person, please complete the order of dismissal, and I will sign it, Mr. Mr. Flanagan will scan it to me and I'll sign it, and then we can get your client a copy also for her records, okay?
Thank you, Judge.
You're welcome. Have a great day. Stay safe. Good to see you.
You too, Judge. Good to see you.
All right. I'm ready on, I don't see Hudson. So I'm ready on, okay, I did that. Loving. Are we ready on Loving? And then are we ready? We're ready on Horton also, right?
Correct, Your Honor. Ready on Loving and Horton.
All right. This is case number 234524001. The people of the state of Michigan versus Marvin Chelsea Loving. The defendant is charged with one count of guns reckless use. Today is the day set for final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson on behalf of Mr. Marvin Loving. Mr. Loving, sir, please say your full name.
Marvin Chelsea Loving Jr.
Today is the day set for a final pretrial conference. How are we proceeding?
Thank you, Your Honor. Mr. Loving continues his plea of not guilty. He asks that this matter be set for waiver trial. Your Honor, I would ask for a final pretrial conference with the people to determine the level of cooperation of any necessary witnesses.
No, Ms. Stevenson, I'm not going to do that.
Understood, Your Honor.
All right. Today is the day set for the final pretrial conference. The court is going to continue a not guilty plea on behalf of Mr. Loving. I will continue the matter to trial, and with respect to the trial, Mr. Loving, your lawyer has indicated that you want to waive your right to a jury trial and have the matter heard by me. Is that what you want to do?
Yes, ma'am.
And sir, do you understand that if I accept the waiver from you today, that you will not have a jury to sit in that jury box in the courtroom, but I would be the only decision maker? Do you understand?
Yes, ma'am.
Has anyone threatened you in any way or promised you anything to get you to waive your right to a jury that was not placed on the record?
No, ma'am.
Any objection from the people?
No objection, Judge.
Having no objection from the people, finding that the waiver has been made freely, knowingly, and voluntarily, the court accepts the waiver. I will set the matter for a waiver trial. I forgot today was February 1st. I was getting ready to say February 5th. That's Monday. That's so silly. Time is moving fast. Mr. Flanagan, do I have a bench trial on, let's see, February the 29th though? Is that enough time for the people to get the witnesses together? Is a February date too soon, or do we want a March date?
Judge, the people would like a March date just to make sure.
All right, what about March the, let's see, we have a trial on March 11th. So that means we're available March 14th for a bench trial. And we can do, Mr. Flanagan, how many do I have already scheduled on March 14th, please?
'26, Your Honor.
And can you tell me, I have in my book that I have scheduled a review or something for the afternoon. Can you tell me how many of those are in the afternoon?
Yes, Your Honor, 5.
Okay. So perhaps we can set Mr. Loving's case for a 12 noon check-in. And then a trial if the people's witnesses appear at 1:30. Now, between you and Ms. Ritter, she can tell you if, you know, before you prepare for trial, she can tell you if she can proceed, but I'm not going to require them to come. That's clogging up my docket. Or I'm not going to put another pretrial on my docket. That clogs me up.
Understood, Your Honor.
Anything further?
No, thank you, Judge.
Nothing on behalf of Mr. Loving. Thank you, Your Honor.
All right, then, Mr. Loving, you're all set, sir, until I just closed my book. What day did I? March 14th. And then you're going to check in on Zoom, Mr. Loving. Well, I don't know how far you live, but the way that it works is that we will check in on Zoom by 12 noon. And if the people's witnesses check in, if they're ready to proceed, then we will come down to court for the 1:30 trial. But if you need, you know, if you have to make it down there, if it's going to take you longer than an hour to get to court, then you might want to just check in person, you know, at 12 noon, okay?
Okay.
Anything further?
No, ma'am.
No, thank you, Your Honor.
All right, then we're all set. Have a great day, sir, and stay safe.
Okay.
You're welcome. Mr. Flanagan, whoops, I'm sending you this order now.
Yes, ma'am.
And then, whoops, true copy it for Mr. Kenny and his client.
Okay.
All right. All right, I'm ready on Horton. Did you all call Mr. Kraft or text Mr. Kraft and tell him to take off his hat?
I did call. I have not received a response. I'll send a text.
Okay. This is case number 04959912, the people versus Gail Elaine Horton. Defendant is charged with one count of operating under the influence of liquor, unlawful blood alcohol. Today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Gail Horton. Ms. Horton, ma'am, please say your full name.
Gail Elaine Horton.
How are we proceeding?
On behalf of Ms. Horton, Your Honor, we would move for dismissal.
On what basis?
I believe the people were to determine their ability to proceed by today's pretrial conference. If that has not happened, I would move the matter be dismissed.
Well, I'm going to deny the motion to dismiss unless the people have some information for me.
Yes, Your Honor.
Ms. Ritter?
Your Honor, so the people tried to locate the necessary officer witnesses in this matter. It looks like this is an older OWI case, and the people are unsuccessful in locating those necessary witnesses. So at this time, Your Honor, due to the age of the case, the people will not be able to proceed.
All right, so the people can't not proceed, Ms. Stevenson. Now your motion might be.
Move to dismiss, Your Honor.
All right, court is going to grant defense counsel's motion to dismiss as the people have indicated that they are unable to proceed as their necessary witnesses unavailable. Ms. Horton, if you would have a seat in the courtroom, we will get you a copy of the order of dismissal for your records.
Yes, ma'am.
All right. Looks like, okay, I had Hudson highlighted. Did Hudson go disappear?
I did too.
Okay, well, let's move on to somebody else. Oops. All right. Any particular order, Ms. Stevenson?
Ms. Hall?
No, any order is fine.
All right. All right, this is case number 174629401, the people versus Keith Van Wooten Jr. The defendant is charged with one count of assault or assault and battery, and today is the date set by the magistrate for review at 8:30. Appearance, please, Ms. Hall.
Brikidia Hall, P number 82954, on behalf of Keith Wooten. Sir, may you state your full name for the record, please?
Keith Wooten.
Today is the day set for a review, and I'm looking at Mr. Wooten's original probation order. I placed him on probation in 2020. August, he was scheduled for a review and a restitution hearing. I don't know if he appeared or not. I haven't had a chance to review the register, but he's clearly been in CPEJ status at some point. Ms. Hall, what do you have to say while I review this register?
That is correct. It's my understanding that he did not appear, at least for the first review date. I'm not sure if the restitution hearing was scheduled for the same day. At that time, he was represented by retained counsel. He was told that he was to complete probation, and according to Mr. Wooten, he attempted to reach out to the probation department quite a few times, and there was someone that he thought was his probation officer who told him that they were not his probation officer and he would hear something from probation. And he never heard anything from probation. He attempted to reach out to his attorney, who also said that they didn't hear anything and they didn't, it sounds like, do anything to try to get him in contact with probation or the court. So up to this point, Mr. Wooten has never made contact with probation and has not completed any of the conditions for probation. He did do what he thought was a community service, or he did perform community service. However, it was not at a court-approved community service location. So he would have to be assigned a probation officer to get back on track. And we are asking that you provide an extension so that he can get back on track. Get on track for probation so that he can complete everything that he was required to complete. He has, in this time, completely changed everything about his life. He is working 2 jobs. He's in school. He has 6 children. He is ready to put this behind him, and he's ready to complete the requirements imposed by the court. And actually, Your Honor, I do want to clarify, Mr. Wooten, according to Mr. Wooten, he has always been ready. He did what he felt like he could do, which is reach out to the probation department, reach out to his retained attorney, and still has not been able to get anywhere with that. So it's not for his lack of trying, and he indicates that it was all of this occurred during COVID, and it appears that a lot of people were not answering the telephone and he was not
in
able
my courtroom. Don't even put that out there like that. That's not the truth. My courtroom answers the telephone.
We did discuss whether he called the courtroom. Because he was represented by retained counsel, he was relying on that retained counsel to do what was needed for him to be done. And he did reach out to that retained counsel, but to no avail.
I wouldn't let an attorney get me sent to jail. I wouldn't. That's just me. So let's go back a little bit. That's a nice story. I mean, I appreciate it. I appreciate the story. I appreciate, coming up with that he tried to reach out to probation, that he tried to reach out to his attorney, and then maybe at that time it was the beginning of, it was sort of, COVID had, been going on for a few months, and it wasn't as many videos as it is out there of me now, because people just, record and replay my stuff, like, make money on my back. I got sidetracked right there, but nonetheless. So it wasn't as many videos out there. And then maybe, he wasn't aware of how precise I am with my instructions. Maybe he didn't remember how I probably repeated myself a couple of times. And then here's the thing. We mailed him a copy of this probation order that clearly on it says your next review date is December 17th, 2020, 9:30. And then it says, and restitution hearing. You didn't need a lawyer to tell you about that. You didn't need probation to tell you about that. All you had to do was show back up on the same Zoom call, same Zoom number that you had been on August the 26th, 2020, when I sentenced Mr. Wooten. So we can blame probation and we can blame Mr. Hiller. But there's nobody to blame but Mr. Wooten. Because at the very least, Mr. Wooten should have been present at the review on December 17th. And then at that time, he would have said, I've been trying to call probation. I've been trying to call my lawyer, and nobody has responded to me. Now, So that's where we are. So no, it wasn't probation's fault, and no, it wasn't his lawyer's fault. It was Mr. Wooten's fault. Now, despite that, I'm going to reinstate his probation. Why? Because people deserve a second chance. People deserve a third chance sometimes. Sometimes we deserve a fourth chance, maybe a fifth chance, right? I just believe that sometimes we deserve chances, but when we get chances, we always operate in truth. It's no sense in me giving a chance if we operating and functioning in make believe, if we operating and functioning in Disney, if we operating and functioning in using our imagination. No, there was no imagination to be needed because the order, it said come to court December 17th. That's what it said. Come to court, next review, and then restitution hearing. Okay, so we're going to reinstate the probation. He has failed to complete the probation in 12 months. There was an original order, the original order was for a delayed sentence. Delayed sentence can only be delayed for 12 months. Can only delay the sentence for 12 months. So his failure to act has cost him the delayed sentence. So it's no longer delayed sentence because this is 2024. And that was in 2020. All right. So the statute says delay, you can only delay a sentence for 12 months. The 12 months has expired. The delayed sentence is no longer available. However, we will continue the probation with everything else except the delayed sentence. And we will set another restitution hearing. They're going to assign, because Mr. Wooten's probation officer is deceased. He's no longer with us. He's deceased. Mr. Jodis was the probation officer before he died. Okay, so now we'll get him a new probation officer. And then, as I indicate to people occasionally, we know that there are several people above and supervising probation. So when we say I called the probation department and nobody gave me a probation officer, then the next thing I wait to hear is that I also called the court room, I called the probation supervisor, I called the probation director, or quite frankly, I didn't even know to call those other people. So I just went straight to the chief judge. Now, what we know is that there is a chief judge that sits on the 5th floor of the 36th District Court. There is also a court administrator. So everybody knows that a court has an administrative department. So a person says, I can't get through the probation. Let me call up there in administration, because they need to do something with the probation and the fact that the people won't answer the phone. And since 2020, August, we've had the same chief judge. There's not even been a changeover in administration in the chief judge's office. Okay, so we're going to reinstate the probation for 12 months with the possibility of being discharged after 6 months. The total that was due at that time is $920. However, there has been an increase in the supervision fees. So we're going to do an amended probation order. We're going to remove the delayed sentence. We're going to increase the probation supervision fees to $35 a month as opposed to $30 a month. The urinalysis testing, at that time, I said he would do it at an outside agency. However, it is the order of the chief that if a person lives in the city, they're supposed to be ordered to go. We have reopened our drug testing lab. So I'm going to increase the drug testing. So for 12 months, it would be $420 instead of the original $360. But if he gets discharged after 6 months, of course, that amount will be prorated. So at the time I fined him $250. I added $135 cost, and I don't know what that is. It looks like it was pre-printed on the form. Oh, that might be the 210 divided up. So the 135 plus 75. And then I had ordered $100 pre-sentence investigation fee at the time. However, I reduced that fee since that time to $50 unless it's a drunk driving case. So the pre-sentence investigation fee is $50. Oversight fees are $420. Drug testing fees are $210. No, drug testing fees. It's $120. And how did my thing just go 0? Okay, let's do that again. $250 plus and then this is increased to $420. And then what did I, oh, 50. At the time, I did not impose an attorney's fee, and I'll leave that. So the total fines, costs, and fees are now $1,050 instead of $920. And then his other conditions was that he had to complete 12 weeks of anger management, provide proof of his education, or participate in a GED program. He was ordered 5 days of community service, clear up any warrants, pay outstanding tickets, and then, of course, no illegal substances, no marijuana without a valid medical marijuana card, or opiates. I indicated that he could not be assigned to a school for his job. So I hope the 2 jobs he has don't include a school. Let's do a restitution hearing and review. So the 12 months, of course, would be February of 2025. That would be January 31st. But let's do a restitution hearing and review on May 2nd that's a Thursday. Let's see, let's do it at 10, I think. Yeah, let's do it at 10 o'clock for restitution hearing and review. All right, anything further?
Nothing for Mr. Wooten, Your Honor. Thank you.
Okay, Mr. Wooten, are we gonna do this? We're gonna do it this time so you don't have to come back and see me?
Oh, yes, ma'am. I tried to do it the first time. I never received a letter though at all. I hadn't received anything, and that's why I tried to reach out. But I'll get it done. I'll get it done though.
Mr. Flanagan.
Yes, Your Honor.
What's the street address? What's the street? Not the strike that. Yeah, what's the street that you have listed for Mr. Wooten? Because he said he didn't get the mail either in 2020. He didn't get the mail.
John Daly.
No, ma'am. I called and changed my address a long time ago as well.
We don't even accept address changes over the phone. That
I'm
means
not talking.
let me speak. We don't accept address changes over the phone. That means anybody could call in and change a person's address and divert their mail. So that's the address that we have on file. And
I was saying I changed it a long time ago. And even with the Mr. Jodas
Mr.
situation,
Wooten, I'm going to advise you to allow the judge to continue talking. I will make sure that they have your updated address.
Okay.
I don't have anything to say. I'm good. Anything further, Ms. Hall?
Nothing further. Thank you, Your Honor.
We're all set. Have a great day and stay safe. Let's see if Mr. Kraft is going to come on screen, and then we're ready on Dyer. I mean, Miss Hall, what's going on?
Can I go into a breakout room with Mr. Kraft?
Yes, I guess so, because I mean, we're literally looking at the back of his head. Literally, we're looking at the back of his head. So let's go. Let's let you go to the breakout room with Mr. Kraft, so that when we come back in, we're not.
Want me to go so you can do Dwyer?
Thank you. Yes.
Okay. Oh, okay. Let's see. Oh wait, I gotta just open. Okay. All right, then I'm ready on Dyer. This is case number 224520101, the people versus Curtis Dwayne Dyer. The defendant is charged with one count of license plate illegal use. Today is the day set for review. Appearance, please.
Rakedia Hall on behalf of Curtis Dyer. Sir, may you state your full name for the record?
Curtis Dwayne Dyer.
Today is the day set for review. And I'm going to print out this review, but while it's printing, oops, I did that wrong, sorry. Let's try that again. Okay. I did receive an update from probation indicating that Mr. Dyer has completed the conditions of his probation, which were not many. He just had to pay the balance and pay any tickets and clear up any warrants. So according to the report from probation, he has paid the balance. For this case, he doesn't have any outstanding ballots with 36 District Court, but he has 4 warrants. He has a warrant in Woodhaven, 2 warrants in Woodhaven. He has a warrant in 27th District Court, and he has a warrant in Oakland County. Ms. Hall?
Yes, Your Honor. Mr. Dyer has completely paid the costs and fines associated with probation. He has also reached out to the other courts where he has the warrants to figure out the amount of what he has to pay for the warrants to get everything set aside. He does say that at least the first 3, that does not include the friend of the court. The warrants total over $3,000. We did discuss getting trying to get on a payment arrangement with the courts to try to get these warrants taken care of and get these tickets paid.
I don't really understand what this said. Okay, Mr. Flanagan, can you pull up? Tell me, okay, this says original probation was, oh, I see what it's saying. Okay. Original probation was for 3 months, February 1st of last year. And then I extended it for 9 months. So in the 9 months, he didn't get on a payment plan? In 9 months, he didn't get on a payment plan?
It's my understanding that Mr. Dyer did not understand that he could get on a payment plan. He thought that he had to pay.
Did he try? Did he call? Did he call the court and say, hey, do y'all get payment plan? What can, I mean, no, okay, listen, this doesn't make sense. It doesn't make sense. It doesn't. What I'm going to do is close him out without improvement. He has 4 warrants out for his arrest. That's his business. if he gets stopped and go to jail, because I tried to get him to not have 4 warrants out for his arrest. So if he gets stopped by the police, he has 4 warrants out for his arrest. There's a chance he might get locked up. Anything further?
Nothing further from Mr. Dyer.
All right, we're going to close Mr. Dyer out without improvement for this case, and then he's all set. Have a great day, sir, and stay safe.
You too.
Thank you. All right. I think Ms. Janzowski was here first, so I'm going to call her, and then I'll do Mr. Edmondson. All right, this is case number 214454001. The people of the state, strike that. That's not the case number. This is case number 224518701. People versus Destiny Rose Jenzeski. Defendant is charged with 2 counts of assault or assault and battery. Today is the date set for review. Ms. Hall.
Rakidia Hall on behalf of Destiny Janseski. Ma'am, may you unmute yourself and state your full name for the record?
Carl Edwin Kraft.
Not you, Mr. Kraft.
Of course not, because you said ma'am and Janzeski. I can't imagine. So ma'am.
Destiny Janzeski.
Okay, thank you, ma'am. All right, today is the day set for review. And with respect to Ms. Janzeski, say your last name again.
Janzeski.
Okay, I keep feeling like I'm saying it wrong.
You got it. You got it.
Let me see, Janzeski. So with respect to Ms. Janzeski, Mr. Hunter indicates that, give me one moment. For some reason, I just had these pulled up and not printed, but okay. Mr. Hunter says that Ms. Janzeski was placed on a 12-month probation last year in March, so she's almost at 12 months. She has paid her fines and costs, submitted to the evaluation, and provided proof from her treatment provider. She's completed 8 of the 12 anger management. And then they said she still has to do a substance abuse evaluation. That kind of confuses me, but Ms. Hall, so she looks like she might need a little bit of an extension.
Actually, Your Honor, so Mr. Hunter has all of her anger management completion certificates up through December, but she has taken a couple classes in January. It's her understanding that she only has about 1 to 2 classes left and that she should be able to get that done within a month.
Okay. Well then, Mr. Flanagan, is she on the docket for oops. Okay, hold on. Is she on the docket for this March 23rd date?
She's on the docket, Your Honor, for March 21st at 10 a.m.
All right, March 21st at 10 a.m.
And Your Honor,
hold on. Let me look in my book. That date sounds funny. March, oh no, I won't be here. So let's change her date to the 20th.
Okay.
The 20th. Okay, Ms. Hall.
Your Honor, I know that you mentioned that she was supposed to submit to a substance abuse evaluation. I will say that at the last hearing that we had where Judge Baltimore was present in your absence, she was ordered to do drug testing by you, random urinalysis. However, all of her drug urinalysis were negative, and so Judge Baltimore did waive change the.
No, he didn't. I know he thought he did, but he didn't. But go ahead.
Okay, so remove the requirement for Ms. Janzeski to do testing, and she also is at a facility
to do the testing.
Yes.
Okay, he discontinued the testing.
Yes, that's correct.
But what is her charge? Oh yeah, okay, that's fine. He could discontinue the test.
assault and battery. So it's my understanding that, I mean, she did complete all of the other requirements, and she has tested negatively, so much so that the drug testing requirement was removed. So I am just asking that she not have to submit to the substance abuse evaluation.
Mr. Flanagan, let me interrupt you.
Okay.
Mr. Flanagan, did I actually order the substance abuse evaluation? Wasn't that something that was supposed to be done for the precinct's investigation? Is there a substance abuse evaluation already in the file?
No, Your Honor.
Yes. Your Honor.
Hold on now. So, Mr. Flanagan, when I first ordered her to probation for the precinct's investigation, I didn't say, like, where did the substance abuse evaluation on my probation order?
Oh, it is, Your Honor, yes. Submit to substance abuse evaluation.
And you telling me that probation has allowed her to be on probation this long and didn't do the substance abuse evaluation? Who is the probation officer?
Agent Hunter.
There's no
I should say, who was it before Mr. Hunter?
I need that.
Looking through the ROA, Your Honor, let me see.
Okay, don't worry, because it doesn't make sense to come to the end of a probation with a person not having submitted to a substance abuse evaluation. That doesn't even make sense. Okay, so I am going to waive it, but I need to send an email, so I'm going to waive it, because why do I need a substance abuse evaluation a month before she's going to be discharged from probation? So I'll waive it. Anything further?
Thank you, Your Honor.
Nothing further from Ms. Jankowski.
Right, so we're all set until March 20th at 10 o'clock a.m.
Thank you, Your Honor.
You're welcome. Have a great day. Stay safe.
You too. Just want this over with.
Okay, give me 1 second, please, or 1 moment, I should say. All right, I'm ready on craft. This is case number 184420701, the People versus Carl Edwin Kraft. The defendant is charged with 1 count of retail fraud. Today is the date set. for pretrial conference appearances, please?
Rakidia Hall on behalf. Oh, I'm sorry.
For the record, Your Honor, Christina Ritter on behalf of the people.
Rakidia Hall on behalf of Carl Kraft. Sir, may you state your full name for the record?
Carl Edwin Kraft.
Today is the day set for pretrial conference. Ms. Hall, how are we proceeding?
Your Honor, this is the first scheduling of the pretrial. However, Mr. Kraft was arraigned in this courtroom on November 29th, 2023, and the corporate complainant was required to appear today. We are asking for dismissal in the absence of the complainant.
Ms. Ritter?
You're muted.
Sorry, Judge, I'm muted. Judge, this case was arraigned on the bench warrant on November 29th, and the court set a pretrial conference today requiring the complainant witness or the corporate complainant witness, someone on behalf of Harper Hospital's gift shop to be present. I don't see a representative on behalf of the gift shop in the waiting room, and they have not checked in the courtroom in person this morning. So at this time, Your Honor, the people will not be able to proceed with this case based on a representative on behalf of the corporate complainant witness.
All right, today is the day set for a pretrial conference. The complaining witness was required to appear. They have failed to appear. The people have no explanation for the failure. They are unable to proceed. The court is going to grant defense counsel's motion and dismiss the matter without prejudice. Mr. Kraft, we will mail you a copy of the order of dismissal for your record, sir. Have a great day and stay safe.
Thank you, Your Honor.
You're welcome.
Good morning, Your Honor.
Please hold on, sir. Okay, this is case number 214454001. The people of the state of Michigan versus Jamar Leroy Edmonston. The defendant is charged with 1 count of retail fraud. Today is the date set for review. Appearance, please.
Rakidia Hall on behalf of Jamar Edmondson. Sir, may you state your full name for the record?
Jamar Leroy Leonard Edmondson.
Thank you, sir. Today is the date set for a review and probation did submit a review indicating that Mr. Edmonston was placed on a non-reporting delayed sentence. He completed the theft awareness class. He still has a balance of $700, and he also has an outstanding traffic balance and several warrants. The 7 months was in September. Ms. Hall.
Your Honor, Mr. Edmonston, he did complete the theft awareness course. He has had quite a few physical issues that's prevented him from working, which obviously means that he has not been able to pay his bills, let alone pay for the traffic tickets. He does anticipate a back payment in March or April. So we are asking for an extension. I'm sorry, Your Honor, an extension of the, or just more time so that he can get the money that he needs, catch up on his bills and pay the tickets required and take care of the warrants.
I would listen to what you just said if he didn't have 2 recent warrants, right? So if a person used to drive without a license and things and such, And then they, trying to get it together. They don't have a job. They don't have this. They don't have that. So now they trying to pay the warrant or they trying to do whatever. But then you're going to get 2 additional warrants in the meantime. So that doesn't even make sense. You adding on to what you already couldn't do. Now, come on. That doesn't make sense. And therefore you get no sympathy from me. Because when he only had 3 warrants, he still kept on getting new warrants. So yeah, no sympathy. Mr. Edmondson needs to get it together. He's already probably in danger of losing the delayed sentence. He has a warrant in 36th District Court, a warrant in 42nd 2 District Court, 17th District Court, 18th District Court, 44th District Court, 23rd District Court. He has an outstanding traffic balance of $968 and a balance with this court for $700. The balance with this court, if he wants community service, we need to talk about it now because he's in danger of some stuff. So does he need community service?
It's my understanding, and correct me if I'm wrong, Mr. Edmondson, that due to a lot of the physical health issues that he has, he's not even able to return back to work yet. But do you need community service, Mr. Edmondson, in lieu of some of the costs and fines?
Yes.
Because I was gonna say, now we got to do something. We got to do community service, or we got to go to. I mean, you got to be able to do one of the two. Mr. Flanagan, did he make any payment, or is $700 the original amount that he owed?
Let's see, Your Honor. That's the original amount owed.
So 700 minus 210. Let's see. Oops, what is my thing doing? So I can convert $490 to 49 hours of community service. That's on my case. That's on this case. He still has an outstanding traffic balance of $968 and those outstanding warrants. Let's get it done. I'm gonna I'm gonna just keep him on for the 2-month date to see where he is. So that will be April. Is he on my docket for April 2nd or April 1st or 2nd?
No, Your Honor.
Let's put him on for April 2nd. That will be his 7-month date under the delayed sentence. 10 o'clock. Anything further?
Nothing further for Mr. Edmondson.
All right, then we're all set, Mr. Edmondson. Let's get it done.
Yes, ma'am.
All right. Have a great day. Stay safe.
You too.
Thank you.